Everyone, Joe Gentili from Saroff Gentili LLP. Like to discuss in this video, if you have a USCIS based denial, if you have an immigration petition that's denied, what are some instances, or what's an instance where you should do an AAO appeal? So when you get a denial, you will see usually at the end of the denial, USCIS will give you some information that says that you could have this reconsidered by filing a 290B form, which is essentially an appeal. And people struggle with whether that's the right move to do. So you could file a new application sometimes. You could file the 290B appeal to the AAO, or you can go file a lawsuit straight to federal court. Normally, in most situations, what I recommend is that if you're juggling between the AAO appeal and federal court, you're better off skipping the AAO and going straight to federal court. And there's a few reasons for this. So number one, most AAO appeals are confirmed. USCIS wins. It's pretty rare that petitioners win at that stage. They take a long time, so they're going to chew up a lot of time. And the other thing is that if USCIS makes a big mistake on deciding your petition, you want to go straight to federal court, because you don't want to give them a chance to kind of clean up their mistakes and give a better version of the denial at the AAO stage, because it'll make a federal litigation that much harder. So that said, I don't give that advice 100% of the time. There are some instances where it makes sense to go to the AAO before going to federal court, even if you think you're ultimately going to end up in federal court. The most prominent reason for that is if you have substantial new evidence that you did not submit with your petition, that you think would be helpful and maybe would change the balance. And the reason is this: when you go to federal court and you're fighting the denial there, the judge can only consider the information that was already in the case, what's called the administrative record. So you're not allowed to submit new evidence at that point, and neither is USCIS. So the judge is locked in to decide based what's already there. And that's why you don't want to give them a chance usually to have a better version of the denial. You want the judge to decide the case on the denial that was made with a mistake in it. However, sometimes that goes the other way. If you have some new evidence that you think will be really helpful, the AAO appeal can be used as a vehicle to submit new evidence that wasn't in your application, so that now a federal judge can use it in deciding your case. So it's really a strategic decision to make with your attorney if the evidence is substantial enough that it's worth kind of the hassle and risk of going through with the AAO appeal. But it is the best opportunity that you have to submit something new before a federal judge would take a look at it. So it's something certainly worth considering. I hope you found this video useful. If you have any questions, please feel free to reach out and subscribe if you're interested in content on immigration litigation. Thanks.